Welcome to Law Sessions. I am Jennifer Housen. In this law session, we will consider duress and undue influence, which certainly are vitiating factors in respect of a contract made. Now, you will see again in this law session that there are overlaps with other areas of contract law. Not least, it may very well be that there is a little overlap somewhere with misrep, among other things. Now then, duress in contract law relates to a situation where a person enters an agreement as a result of threats made to him. Now, where a party enters a contract, because of duress, they may have the contract set aside. Now, originally, the common law only recognized threats of unlawful physical violence. However, we've seen a recent shift in regards to how the courts will look at it, in that the courts have recognized economic duress as giving rise to a valid claim. Now, economic duress, of course, is and the extent to which it goes is way outside the ambit of contract law, and certainly it is founded on a claim in the law of tort. But nonetheless, it shows that the issue of duress is not just confined to personal threats. Now, where the threat is to goods, the courts have been less willing to intervene. They prefer to look at it when you're considering a threat to persons. Although you may, of course, see claims which are analogous in restitution, which suggests that this position of the law may in fact change. Now, the basis of the duress is, as I said earlier, a vitiating factor in contract law, in that it shows an absence of this freedom to consent. Now, remember, the whole idea of contract is this freedom to contract. And freedom to contract, of course, includes a freedom as to consent. Now, duress operates at common law. Pressure not amounting to duress may give rise to an action for undue influence. Now, undue influence, certainly you can look at it from equity, and the effect of a finding of duress and undue influence, as I said, is that it will make the contract voidable. Now, the innocent party may rescind the contract and claim damages, and the normal bars, of course, will operate. For example, if you're seeking to rescind the contract, then any bars to rescission, such as lapse of time, will obviously affect that. Let's start by looking at duress to the person. Where a person enters a contract as a result of threats of physical violence to him, then the contract may be set aside, providing the threat was a cause of entering the contract. It may not be the sole cause. It just may be a cause. Now, there is no need to establish that they would not have entered the contract but for the threat, as long as it is, as I said, one cause of them entering the contract. Now, the interesting position on this is in the Australian case of Barton and Armstrong. It's a Privy Council case from 1976. Armstrong was the chairman and held the largest shareholding in Landmark Corporation, which was a public company. Barton was the managing director and also had a substantial shareholding in the company as well. There were two other directors, Boville and Cottrell. There had been a long history of ill will between the parties, and there was obviously a power struggle over who should have controlling power, with Armstrong being the most aggressive. The other directors in the company were also unhappy with Armstrong and wanted him to be removed for abusing certain privileges, and they disagreed with the way he ran the company, believing him to be putting the company at risk of insolvency. However, Armstrong refused to resign. The three managed to take control of subsidiary companies and removed all credit facilities from Landmark Corporation. When Armstrong discovered that the credit had been removed, he made a number of death threats to Barton to pressure him into signing an agreement which contained various elements, including the purchase by Barton of Armstrong's share in the company at a substantial overvalue. Now, Barton agreed to this partly due to the threats, but also due to the fact that it would mean that Armstrong would no longer have controlling interest, and he believed he would be able to turn the company around without Armstrong being involved. However, unfortunately, the company became insolvent shortly after, and Barton sought to have the contract set aside. The court said the contract could be set aside because where there is duress to the person, there was no obligation to show that he would not have entered the agreement but for the threat. That's not it. It's not a be-all or end-all. It simply is sufficient that the death threats were a cause of him entering. Now, what about duress to goods? Well, duress to goods is not recognized as giving rise to grounds for having the contract set aside. Case to consider is Skeeter and Beale. There, a landlord was owed money by a tenant. He seized goods owned by the tenant and threatened to sell them immediately unless the tenant entered an agreement for repayment of the sums owed. Now, the tenant agreed to the repayment terms, but then sought to have the agreement set aside for duress. The court said duress to goods will not be sufficient to render a contract voidable. It is thought, though, that the position in relation to duress to goods is unlikely to survive if it is tested in the higher courts, particularly given the more liberal position that has taken place recently, not least in the context of economic duress. And speaking of economic duress, what is it? Well, the doctrine of economic duress was first canvassed in a case called the Sibian and Sibetry. And whilst the contract there was not held to be voidable for duress, Justice Carr in the case did say that where there exists coercion of the will so as to vitiate consent, it should be possible to set the contract aside. However, commercial pressure, he said, was not enough. Well, let's look at Sibian and Sibetry. The case is called Occidental Worldwide Investments with a subnom of the Sibian and the Sibetry. It's a 1976 case where the defendants chartered 2 vessels from the claimant. The defendants told the claimants that they would go bankrupt if they did not lower the cost of the charter. This was completely untrue, of course. The claimants feared that they would lose valuable customers, and they were also owed substantial amounts of money by the defendant, which they feared they would lose if the defendants did become insolvent. Now, the claimants agreed to renegotiate the contract to lower the cost of the charter. They later sought to have the renegotiated contract set aside. The court held that whilst recognizing that it would be possible to render a contract voidable for economic duress, it was not established in this case. To amount to economic duress, there had to be a coercion of the will so as to vitiate consent. Commercial pressure was not sufficient. Here, we did not see anybody's will being coerced or overborne. It was really a commercial decision taken, it appears, simply because they were afraid they would not get paid. Now, this was the first case where the economic duress was recognized, and given the rise of the cause of action, you would arguably say that when you look at it from its more recent cases, the recent cases look to an absence of choice rather than coercion of the will, vitiating consent. Indeed, there's a case, the Universe Sentinel, which, following Justice Carr's line of reasoning, economic duress was found to exist in the Atlantic Baron, which is the same case. However, in that case, the claimant lost their right to rescind. So if we just have a quick look at the case is actually called North Ocean Shipping and Hyundai Construction, called the Atlantic Baron. The defendants agreed to build a ship for the claimants for a certain price, which was specified in US dollars. After entering the contract, the US dollar was devalued by 10%. Now, the defendants threatened not to complete unless the claimants paid an additional 10% on top of the contractual agreed price. Now, the claimants had a valuable charter lined up, so they agreed to pay the additional sums and did pay them without protest. 8 months after delivery of the ship, the claimants brought an action to recover the additional sums that they had paid out. The court said that the contract was voidable for duress. However, since the claimants had left it for so long in bringing the claim, they had affirmed the contract and they'd lost their right to rescind. If somebody is going to put you in that position, then the court is not saying that it will not allow economic duress to be used, but you really ought to be bringing the action as soon as, or as immediately after as you possibly can, otherwise the courts will consider that you've waited far too long. And that's exactly what happened in the Atlantic Baron. In Pawan and Lau Yu Long in 1979, case we've looked at before when we looked at contract formation, the claimant had threatened not to complete the main contract for the purchase of shares unless subsidiary agreements were met, including a guarantee and an indemnity. Now, the defendant was anxious to complete the main contract as there had been a public announcement of the acquisition of shares, and he did not want to undermine public confidence in the company and the consequent effect on the share prices. Now, the defendant could have sued for specific performance of the agreement, but this would have delayed matters and damaged the company's reputation. Well, the defendant had taken legal advice on all these matters before agreeing to the guarantee and the indemnity. The claimant then sought to enforce the guarantee, and the defendant sought to have the agreement set aside for economic duress. The court said there was no economic duress. The Privy Council identified 4 factors to consider in assessing whether economic duress was present or not. And they are these: did the person claiming to be coerced protest? Did that person have any other available course of action? Were they independently advised? After entering into the contract, did they take any steps to avoid it? Well, in the present case, the defendant did not protest at the time. He also could have enforced the contract of sale through specific performance and thus had another avenue of redress available to him. He had taken legal advice and took no steps to avoid the agreement prior to the claimant seeking to enforce the guarantee. Therefore, the court said, no economic duress could be established. It was simply commercial pressure, which was far below the standard required for duress. Now, the requirement of vitiation of consent was replaced in the Universe Sentinel with the absence of choice. Now, I want you to digest that for a moment, and what we'll do now is break for a short moment, and then as soon as we return, we will look at the position in the Universe Sentinel.